Foster Care Committee, Wednesday, February 15th. We are going to jump right into things. Just one addition to the agenda today. You received minutes, I think earlier today. Yeah, earlier today for January 30th. And so I'd like to, when we get all of our other business wrapped up, I'd like to get approval of those minutes if we can today. If you have a chance to look at them, we certainly don't want you to not pay attention to the rest of the committee meeting, but if you haven't had a chance to take a look at them, you might pull them up. Okay, so we are going to have a hearing now, open the hearing on House Bill 2377, and ask Jesse to give us an overview of the bill.
Thank you, Madam Chair. Good afternoon, committee. House Bill 2377 amends two statutes that are related to the disclosure of records that are held by the Office of Vital Statistics. The Office of Vital Statistics is found in the Department of Health and Environment. So when we're talking about this, I'll make sure to differentiate which secretary is which when we're talking about the secretary for KDHE and the secretary for DCF. So the changes in this bill are changes that relate to the secretary for Children and Families and courts accessing birth and death certificates and records of those involved in child in need of care proceedings. So the first section, the bill amends KSA 2418. This is the statute that authorizes the Secretary of Health and Environment to set fees for records when requested. So this bill amends the statute to direct the Secretary of Health and Environment to neither charge or accept fees for a birth or a death certificate of a child who is a subject of a child in need of care proceeding, a party to a child in need of care proceeding, or even an alleged party to a child in need of care proceeding, if those records are requested by the Secretary for Children and Families or a court with jurisdiction over the proceedings. The bill's second section amends KSA 652422D. So this deals with the disclosures of those records from the Office of Vital Statistics. So this statute directs the state registrar to issue certified copies of death or birth certificates of those same individuals, a child who is the subject of a child in need of care proceeding, a party to a child in need of care proceeding, or an alleged party to the same proceeding, when those are requested by the Secretary for Children and Families and a court with jurisdiction over that proceeding. So when the state registrar, when there's a request being made, the state registrar usually asks for a journal entry related to verify that the child is a child in need of care. When they receive that initial journal entry establishing that the child is a child in need of care, that registrar is required to provide the requested records within 48 hours of that request. And that is House Bill 2377.
Okay, committee, do you have questions for Jesse? Representative Underhill.
Thank you, Madam Chair. What is the definition of party? And the reason I ask is I have experience as a kinship foster parent and proving relationship and that sort of thing. I've had to go back a couple generations.
Yes, definitely. I don't know it off the top of my head, but party is defined in the sync code, so I can find that for you. And then there's also a section in the sync code that allows people to become interested parties. But in the practice of this, you're really looking at birth parents and blood relatives in regards to the birth and the death certificates.
Further questions? Okay, thanks, Jesse. Okay, we'll open up the proponents, and first up we have Rachel Marsh with Children's Alliance of Kansas. Welcome, Rachel.
There we go. Hi again, my name is Rachel Marsh with the Children's Alliance of Kansas, and I'm sorry that you're missing the Chiefs Parade, but nonetheless, I will be here to testify in support of HB 2377. Very briefly, this bill triggered my memory of some very frustrating experiences that I have had in the past years ago with trying to access birth certificates for children in need of care, particularly for adoption purposes, is when it really matters, the timeliness of it. But I want to start at the beginning. When a child enters the foster care system, they often come in without a birth certificate. Not that there's not one, but that it's not kept in a fire safe like I have in my OCD household. So without the birth certificate, we have to seek one from the Office of Vital Statistics. And when we do, there are barriers that seem unreasonable. And so I submitted my testimony, which you can read, but I also, when I sent my testimony out to our members to say, am I on target? Is this still a concern? This is what I got back. I am so excited to see this being discussed. This has been a significant barrier for our staff. Another response was interesting. This topic just came to me on Wednesday from our internal staff. Important update from the Vital Statistics Office. Vital Statistics has changed practice. If the journal entry is outdated, they will not accept the journal entry to show that the child is in care. You must submit the most recent journal entry, and it can't have the next court date pass, or we have to send you back to go get a journal entry, even when an adoption might be pending and have to be delayed. Finally, we have a response that says we have one quality assurance worker assigned to requesting birth certificates because of all the time it takes to navigate the bureaucracy. It continues to delay the adoption process. We have recently had to have legal counsel become involved to attempt to help us in this process. So I believe that our members kind of speak for the issue. We do need to have the Vital Statistics Office support permanency and legal documentation for children in foster care rather than be a barrier. And we are happy to stand for questions at the appropriate time.
Well, this would be the appropriate time. Committee, do you have questions? Rachel.
May I go out of order and ask one thing I forgot?
Yep, you may.
In the Child in Need of Care Code, it lists the secretary or designee so that the secretary personally doesn't have to request a birth certificate. And since this is not in the Child in Need of Care Code, presumably, we would ask that you, if you do pass this bill, that you would amend it to secretary or her designee so that we can make sure that the bill solves the problem of actually having contractor workers seek birth certificates. Apologize for forgetting that.
Representative Humphreys.
Thank you, Madam Chair. So I don't think I heard you say this, but is there a, so it says that they, never mind, I answered my own question. Thank you.
Thank you.
Representative Lewis.
So it's the Bureau of Vital Statistics that, thank you.
Yes, Representative.
And have you or do you know somebody who's spoken to them about this problem, and do you know
I believe
how they explain themselves?
that that will be maybe the next
Somebody-
conferee.
Okay, very good. Thank you.
Okay, further questions? All right, thanks, Rachel.
Thank you.
So are there any other proponents to speak to this bill? Okay. I don't show any other testimony. Is there anyone here to speak neutral or opponent? Okay, Secretary Howard. I kind of thought that that was the case, but.
Thank you, Madam Chair and members of the committee. Secretary Howard, to speak, I guess, neutrally on the bill. I'm actually speaking to you on behalf of both myself and Secretary Stanek from the Department of Health and Environment. Since this issue came to my attention in December, we've begun to have some conversations between the two agencies. As Rachel testified and as Jesse indicated, you know, what this bill would do is waive fees in vital statistics for birth and death certificates related to children in the custody of the Secretary DCF, and it would also detail a specific procedure to follow in order to provide those certificates. We both believe the intention behind this bill is a really important one, but we also believe, and as it was indicated, delays in vital records can mean delays in an adoption going forward, and so we all need to be partners in permanency. While we really believe they should be expedited, we are committed to finding an administrative way to make this happen. We don't think that this requires legislation. There's a fiscal impact on my sister agency, KDHE, of about $98,000 if this goes forward. And it also would, set a precedent perhaps for exemptions within the Vital Statistics Act. We believe that we can reach an agreement through a memorandum of understanding between the two agencies that would basically end with the same effect. Having those expedited access to those birth certificates and creating a more simplified process for ourselves and our designees to follow in requesting those. So we would appreciate the opportunity to work on that memorandum of understanding and to do that administratively rather than detailing a specific process in statute. So that's my testimony really on behalf of both agencies, and you have both myself and Secretary Stanek committed to making that happen between the two agencies. Happy to stand for questions.
Thank you. Thank you, Secretary Howard. Do we have the fiscal note on this?
Yeah.
I'm not finding it on the S drive. Where'd you get it then? I don't need to say it, I just want to. I'm impressed. Oh, okay. Okay, are there questions for Secretary Howard? Representative Howerton.
Thank you, Madam Chair. So who pays the fees for those documents right now?
That's paid by the entity requesting that, but for example, like with our contractors, we make payments to our contractors. So that's included within those. One of the thoughts that we had as an agency in our beginning conversations was that perhaps within that MOU, we could just centrally within DCF make a payment on like a quarterly or annual basis based on the number of requests to eliminate that whole payment issue as each individual request is made, and then define the process in a way that's very similar to what the bill would do in terms of expediting that.
Follow up, Madam Chair. So the first conferee said that this has been an ongoing problem, and you said you just became aware of this in December. So I'm just trying to figure out why they felt they had to bring a bill when this has been ongoing and not addressed prior.
Yeah, I can tell you just a little bit of maybe the history behind this bill. I think where it originally initiated and what came to me to learning about the issue was actually one of my own staff attorneys who was participating in the University of Kansas Certified Public Manager Program this past year, and you have to do a capstone project there. And when I attended the graduation, I was asking her about her capstone, and she said, gosh, it's about getting birth certificates and delays in adoption. And I said, so tell me more about that, and began to hear more about that issue. So we had begun to have some initial conversations with the Department of Health and Environment, but we had not intended to bring forth a bill unless we couldn't reach an agreement. And then I think as folks learned more about the conversation and the work that had been done there was just really a lot of excitement about saying, wow, this is an issue people have been experiencing. This might be a way to get this resolved now. So again, I'm not critical of the fact that the bill was introduced by any means and totally support a resolution to this. We just believe that we can do this administratively without having perhaps some unintended consequences more on the Kansas Department of Health and Environment side, and maybe setting some precedent within the Vital Statistics Act that we might not want to see. We believe we can make this happen.
A follow-up. So how long will that take?
Well, we're beginning those conversations now. We'd be happy to report back to you during the scope of this session. So I think it would be my goal that, if this bill were to pass, it would be something that would be in effect July 1. It would be my goal that we would have a memorandum of understanding in effect, by that same time period.
Representative Humphreys.
Thank you, Madam Chair. So did you say if you did a memorandum of understanding that you would have in it a time period where you had to get the certificates out to them?
We would. We would, in the agreement between the two agencies, there would be a time frame within which Vital Statistics would have to provide their certificate. And I think we would just want to look at the whole process and say, when the child comes into custody, what becomes sort of that standard practice as to when those documents are requested, so that we're not late in the case when that happens. And I think also addressing the issue that the prior conferee talked about, so that, for example, if the court order was out of date, that sort of thing, that wouldn't get in the way of getting the certificate. So again, I think we would just detail out what is needed in order for that to be provided in a way that there wouldn't maybe be kind of quibbling on behalf of whoever maybe that staff person is at Vital Statistics. They would have a clear policy and procedure in front of them to follow with any child welfare request.
And you said the entity requesting it is the one that would be paying, that now pays a fee. So are those the grantees or are those the child placing agencies?
Yeah, in
Or
most cases,
who is
it
that?
would be in most cases, it would be our case management providers.
management,
Yeah, I mean, at the point of, and usually where this really becomes an issue is if the birth certificate isn't available at the point where we're talking about adoption. So I would think that at a minimum, we would want to, in a memorandum of understanding, have a process whereby whenever the case plan goal changes to adoption, that all that documentation is immediately requested.
And do you know what the fees are?
I don't know off the top of my head what the fees are, but certainly as
I think it's $20 to file a
Thank
birth
you.
certificate, and it's $20 to get a copy of the birth certificate. But, so my question is, I'm just kind of curious about that fiscal effect. So they feel like from these cases where a child that's in state custody that doesn't have a birth certificate, there's $98,000 worth of fees that are lost when it's either $20 or $40 each?
That's correct. When KDHE did their fiscal note, they looked at the number of requests that they have today for both birth and death certificates in this instance. And those resources, of course, go into funds within KDHE that fund specific programs.
Thank you. Thank you.
Representative Wagner.
Thank you, Madam Chairman, and thank you, Ms. Howard. I guess the question I have here, do you have, if I'm understanding the issue, I don't know if so much it's the charge, but just how fast, that it's just a delay in getting certificates. I mean, do you have like a standard that you're supposed to get them in 24 hours or anything like that? Is there some sort of internal quality standard in this department?
Thank you for that question. I think that really is, at this point, really the core of the issue is less about the financial cost and more about the process and the delays that take place if the right form isn't provided, things like that. So, for example, right now, within the Office of Vital Statistics, KDHE would typically provide things, their standard would be within 10 business days, but they certainly can do that sooner and have committed to, even within their own fiscal note, have indicated that they could do that within 2 business days. So we would intend to put in a short time frame within that memorandum of understanding so that there isn't delay, and also define what they need to accept in terms of a form in order to do that, and not have the kinds of delays and repeat requests that sometimes have to happen just because a court order is out of date. So.
Follow up. So, I mean, you know, again, as I'm looking at the bill, it just talks about the cost. It's not, but it seems like the problem really is the speed and the delays. I guess I am curious, why, I mean, why would it be, I mean, 48 hours maybe makes sense. I mean, 10 business days seems like incredibly awful as far as by any sort of large corporate standard, if I was dealing with a big corporation. I mean, what is the problem? I mean, it's not like it's a piece of paper someone's going in some file cabinet, you know, 5 stories below or something. I presume everything's online, you know, it's a photocopy, not a photocopy, but it's on, you have it on like your website or on your internal web, would you not? Or what causes the delays?
Well, I mean, I think I don't want to speak too much for the Department of Health and Environment, but, you know, they get a significant number of requests for, you know, vital statistic records. And so partly it's just the quantity of the demand. And so I think that's why one of the really valuable pieces of this bill that we would want to mirror in a memorandum of understanding is really setting a priority around those documents in these circumstances and really setting a criteria, you know, as this bill would do, that it would talk about upon receipt of the very initial journal entry that the registrar would provide that certified copy. So again, that's the sort of thing we would looking at within an MOU between the two agencies. And again, I have the commitment from my colleague at Health and Environment, Secretary Stanek, to look at how we might accomplish that.
Representative Underhill.
Thank you, Madam Chair. How often do you do MOUs with KDHE, and how effective are those, or do you know how often legislation has to be passed in order to produce accountability? Because we don't want to see the ball dropped on this if the MOU doesn't come to fruition.
We actually have existing MOUs with Department of Health and Environment related to some things around our benefit programs and also related to some shared responsibilities related to licensing of child care and foster care. So it's not unusual at all for us to have memorandums of understanding. They work, they're accountable. And as I said, you have my personal commitment and that of Secretary Stanek that we will make this happen and address this issue.
Representative Howerton.
Thank you, Madam Chair. I'm sorry, I just cannot get past these numbers. So 98,160 is the loss of revenue. $20 for a birth certificate or a death certificate. That's 4,908 a year. Does that sound accurate?
I think that's possible. Yeah. I mean, what the Department of Health and Environment did in developing their fiscal note, I think I have that in front of me, in fact. Let me just look at that real quick. Was look at what the history has been around providing these, and they just calculated it based on that. Yep, I mean, that's what they looked at their records in terms of the number of requests that they had related to these records.
Would there be, that's the loss that they would incur from not taking in the fee. Is there a consideration for employee time? I guess the time would be used either way. Never mind.
Yeah, Madam Chair, I think the only thing in their fiscal note that related to staffing was if the intent was for like a 2 calendar day turnaround that might include weekends as opposed to 2 business days. And they clarified in their business note that if it was including weekends, they would need like additional staff, but they wouldn't if the expectation was 2 business days. So,
Yeah, the bill did say 48 hours in it.
Yeah.
Okay. Okay, other questions? Okay, thank you, Secretary. Okay, I'm going to call on Jesse for an answer to Representative Wagner's question.
Oh, this is for
Underhill?
Representative Underhill.
Okay.
Yes, so the representative asked a definition for party. So in the sync code, party is defined as state, petitioner, child, any parent, or an Indian child's tribe intervening in the case. As a conferee mentioned, this deals with the Uniform Vital Statistics Act, and it's not in the sync code, but it could be, so therefore that definition does not directly apply, but it could be reasonably inferred, or just the definition of a party in a normal court action could be applied.
Thank you, Jesse. Representative Underhill.
So Jesse, am I correct that like one of these placement agencies doesn't fall under that definition of party?
Jesse?
Madam Chair, so I think it could, if it is a designee of a state agency, possibly. But thinking of the practical effects, the birth or death certificate of an agency.
Okay. Secretary Howard, did you want to be listed as, did you say neutral? Okay. Is there anyone else who wishes to speak to the bill? 2377. Okay, we're going to close the hearing on House Bill 2377, open the hearing on House Bill 2361, and I'll ask Jesse to give us an overview.
Thank you, Madam Chair. Good afternoon, committee. This second bill hearing is going to be on House Bill 2361. This bill amends a statute we are familiar with. It is 382700. This is a statute that directs the court to enter orders for the placement of a child in need of care in custody for adoption. So you're thinking about the court entering the order saying who has custody over a child with the intent that custody is for adoption. So in subsection B, when the court is granting custody under this section, the court gives certain preferences. So the statute directs the court to first give preference to a relative, and then second to a person with whom the child has close emotional ties. This bill only has one amendment, and what it does is it adds a sentence to that subsection stating that the subsection B, that subsection, would not apply when the child who is the subject of the proceeding has been in custody of the secretary more than one cumulative year. So if the child has been in the custody of the secretary for a cumulative year, the court shall no longer apply what is required in that subsection B.
Okay, thanks, Jesse. Are there questions for Jesse? Representative Carr.
Thank you, Madam Chair. So if I understand this correctly, first preference goes to a relative, correct? And second preference goes to a person with whom the child has close emotional ties. How do we define close emotional ties, and at what age of a child are we talking about? How do we determine that a 6-month-old has close emotional ties?
Certainly. Representative Carr, you are correct. So it first goes to a relative, and then second, that close emotional ties. The sync code does not define close emotional ties. And so that is a factored analysis that the court does each time they enter this order or determine whether or not a child has close emotional ties. So there's no set definition for that.
May I?
Yes, go ahead.
With that being said, and again, I'm new, so I'm not certain. This would be a child that is already in foster care, that would have gotten there by any means or any number of particular means. Is there, or there isn't, in this particular bill, any preference given to culture? It's only for the So the preference here is only given by the judge for the initial, in the initial care for the child, for the foster care in which those emotional ties could or could not have been built if in fact there was no immediate family member or relative for which to relinquish the care of the child for that interim period of time. Is that correct?
Representative, I hate to do this, but could you ask the question again?
Okay, so let me
apologize.
let me rephrase that. So the judge then has the ultimate responsibility for directing that child's foster care with only regard for these two items listed.
Correct, and that is the order related to the adoption. So when we're thinking of whatever has happened before in the foster care situation, you're only looking at these people in the context of who shall adopt that child. And they are guided by those two items.
Okay, thank you.
So, yeah, the foster care system has the placement agencies that make those decisions. Is that what you were asking?
Yeah.
Or is the interim placement?
Yeah, she answered that. So, and this is just for the final adoption of the child.
Yes.
That's correct. Okay.
Okay.
Thank you.
Other questions? Representative Wagner.
Okay. Jesse, it says, this subsection shall not apply when the child has been in the custody of the secretary for one cumulative year or more. So when the child has been for 1 year or more, then what is the standard used in granting custody? Is up to the judge, or is there some?
Yes, Madam Chair, Representative Wagner. So when you're talking about custody of the secretary, that can be any sort of order of placement. So when we're thinking about in the custody of the secretary, the child has been determined a child in need of care, and throughout their care, up until this order of adoption, that would be counted in that custody of the secretary for a year or more. Is that?
No, I got that time frame, but it said the subsection shall not apply when the child has, so if a child has been in the custody of the secretary for over a year, then what is the alternative way that this is handled? I guess I'm.
Yes, Representative Wagner. So the bill does not indicate how the court should grant that order once a child has been in the custody of the secretary for that year or more. So this only states that this direction of relative and then close emotional ties ends. The court shall not, at that point, 1 year, no longer does this analysis in granting that order.
Okay, further questions? Okay, thank you. Oh, sorry, Representative Lewis.
Thank you, Madam Chairman. Just following on, and you may not know this, but why are we limiting it to a time period for the analysis to apply?
Sure, that would be a policy question for the requester of the bill.
Okay, further questions for Jesse? Okay, thank you. So I only show one proponent, Sister Therese. I kind of called you as if it was a question. I wasn't sure whether you were going to testify orally or written. So
Well, Chairwoman Concanon, community members, staff, each and all. I'm Sister Treese. I'm a sister at Charity of Leavenworth, and I like to remind people that we were involved in child care, child welfare from our beginnings. Those tough pioneer women who were our founders brought an orphan with them to Leavenworth when they came in 1858. The children that are in the Kansas child welfare system hold a special place in my heart. They claimed that place back in 1973 when I worked at St. Vincent Home here in Topeka. For 3 years, I was a teacher there. For 6 years, I was a child care worker. It was a residential treatment home. This experience was my beginning teacher about the children who, for multiple reasons, were not able to be in the care of their parents. From these children, I gained a son. I am his mom. It's not an honorary title. We walk the walk. He was the first one to teach me what it was like to belong to no one. He is now 50 years old. I watch him deal almost daily with the wounds of his childhood trauma. He is an accomplished fine dining waiter, compassionate and honest, but his childhood still exacts a toll from him. I also served as a CASA, a court-appointed special advocate. This was another learning experience as I went to court with children. In the interest of time, I'll spare you those stories. House Bill 2361, from my understanding, gives DCF a clear legal reason to allow a foster family to adopt a child if that child has been with them for over a year. I am still haunted by the story of the 3-year-old in Wyandotte County who was recently removed from the only family she knew. She came there at 3 days old, the only family who had cared for her. She was taken to live with half-siblings with whom she had interacted, from my understanding, for 10 hours. Her cries, as reported, as she was taken away, "I want to go home." Those cries ring in my heart. I want to go home. She knew what was happening. She also knew where home was. I need to add here that I am grateful that DCF is appealing the judge's decision in this case, and to tell you that my knowledge of the case is from Kansas City Star reporting from a journalist that I trust. I believe we have learned more about childhood trauma since the 70s when I worked at St. Vincent's. I'm not sure those learnings have permeated the systems. I do know that this 3-year-old has been traumatized, and I believe the brother with whom she shared home has also been traumatized, not denying the anguish of the foster parents. I would like to believe that House Bill 2361 can help prevent another child from being so traumatized. I have attended the majority of the Child Welfare and Welfare Reform Committee meetings in this room during this session. I have noted that over half of you serve on both committees. I want to thank Representative Hoagland for publicly sharing yesterday her knowledge, experience of what can happen to children and parents around our child support enforcement rules, helping to focus us on our laws meant for good. We all want children to have resources from a non-custodial parent, but also those same laws' potential to cause harm. As you make laws for vulnerable adults and children in this state, please remember that it was very likely that a number of the adults are from childhoods that are born out of this system of trauma. I want to conclude my testimony today with a story told by Dr. Carl Menninger. He was a pioneer in the treatment of mental illness. He is known around the world. Dr. Carl's name is in one of those Kansas frames, along with Bob Dole and Pat Roberts and other Kansans on the sidewalk here on the Capitol grounds. And he shares, A 5-year-old girl stood in her crib in a ward of the Neurological Institute erect, motionless and mute. A few weeks prior to her admission, she had suddenly become strange, refusing to answer to her name, refusing to eat, refusing to remain in bed. She would wrap herself in a dirty blanket and turn her face to the wall, wetting and soiling herself. One of the nurses remembered that upon one occasion, she thought she heard this child say in a sing-song rhythm, "Say you're sorry. Say you're sorry." On this clue, a doctor took the child's hand and said to her seriously, "I am sorry. I am very, very sorry." Upon this, the child turned slowly to the other doctors and said, "Say you're sorry. Say you're sorry." And each of them did. Then she began to talk. A week later, she was acting like other children again, and she continued to have therapy for 2 years. Dr. Carl concludes, "One wonders how frequently another child's life or another person's life would be changed this miraculously if they could be told in the right way, at the right time, by some of the rest of us that we are sorry." Well, are we? Thank you for hearing me today. Thank you for being willing to serve on this committee. Foster care stories are not for the faint of heart. Though some, I believe, would say that Appropriations is the most prestigious committee in this legislature, from my eyes, you are doing the most important work. Remember your power. You have my prayers. And if you have questions, I'd be happy to try to answer them.
Thank you, Sister. Committee, do we have questions? Okay.
Thank you.
So I don't show any other conferees on this bill. I might, just to answer Representative Lewis's question, I brought this bill, and I think maybe you have a little more understanding where it was coming from. If you have any questions for me regarding that, that's fine. Oh, Representative Howard, you do have testimony. Okay. Oh, what did I call her? Representative Howard. Sorry.
Thank you for the promotion, Representative.
No, Secretary Howard.
I apologize for
Yeah,
I apologize for confusion with the testimony on both.
No problem, no
bills.
problem.
You should have my testimony in front of you, though. It's very brief. And then I think we also provided a copy of the report from the Judicial Council and the work that they did this summer related to the issue of attachment. So I appreciate the chance to give neutral testimony on House Bill 2361. You know, as Jesse described it, you know, the bill would limit that preference given to close relatives during adoption proceedings if the child's been in the custody of the secretary for one cumulative year or more. You know, the whole issue of attachment is a really, really critical issue that many of you on this committee have been focused on for a while. I'm looking at Representative Humphreys. You know, last session, after Representative Humphreys had a bill that was considered and then made a request to the Judicial Council along with Representative Kincannon that there be a review of that issue of attachment in child placement decisions and adoption proceedings made in sink cases. And again, very much of this really tied around the issue of when particularly a young child has close ties with a foster parent. And and the preference related to relatives. And so I think what my ask to this committee would be is that you would really take a close look to the recommendations made from that and the legislation that the Judicial Council recommended. I think they took a very, very thoughtful approach to addressing a really important issue. They really were trying to, assess how legislation could require, attachment assessments, and how an attachment to a non-relative caregiver can be balanced with the federal emphasis on keeping children with relatives. And so they spent a considerable amount of time, and I think on the very first page of that document, you'll see the members of that committee, lots of expertise, judges, district attorneys, advocates, CASA, and a couple of legislators as well. And so they really, I think, came forth with some really positive legislation. And we would just ask you to consider that. Some of those elements are actually in House Bill 2299 in front of this committee that were included within that bill. But I think that you have a lot of different bills in front of you that impact the sync code, and I think that it's the sort of thing that there could be unintended consequences if there's maybe a reaction maybe to a specific case or a specific instance. I think the Judicial Council did a very good job in kind of filling a gap in our existing statutes to clearly call out the focus should be on the best interest of the child and to clearly call out the issue of when foster parents should be considered. And their bill is actually on their language is on page 16 of their report. And again, some of it will look familiar to you because it is, some of those provisions are included in House Bill 2299. But again, I would just ask you to give consideration to the work that was done over a several months period that I think may not address every issue or concern that's been brought up in the varied bills before the committee, but I think would make a very good step forward in making sure that our sync code speaks directly to the issue of attachment and speaks directly to the issue of when a child has been with a foster parent for a period of time and has that attachment with that foster parent. So again, that would just be my recommendation to this committee in giving the neutral testimony on this bill, knowing kind of I understand where the sentiment and intent comes from these. I've obviously been very much engaged in some of the particular case issues that have gotten a lot of attention, but I really believe the report, the recommendations made by that advisory committee are really thoughtful improvements that would very, very clearly call out the issue of attachment and the issue of those circumstances where a child has that bond with a foster parent. So thank you for the time to provide this testimony.
Thank you, Secretary Howard. Do we have questions for Secretary? Representative Owsley.
Thank you, Madam Chair, and thank you, Secretary, for your testimony, and thank you for providing the Judicial Council report. Do you feel like if we were to adopt the Judicial Council report recommendations, that it would capture both the intent and sentiment of 2299 as well as 2361, as they both touch on the same KSA?
I do. What the Judicial Council recommendations would do, I mean, early in the process, and when we at the agency level are making some of those decisions about the best interest of the child at a time of adoption, it would really put those issues up front, which I know that some of the bills you've looked at have added some provisions targeted very specifically at the court and an action they should or shouldn't take when there might be an appeal. I think that those would be far less likely to be even in play if these provisions were in place earlier in the process so that we were already considering in a very, very specific way under the Kansas law the issue of the attachment and the relationship with the foster parent.
Thank you, Madam Chair, and thank you, Madam Secretary.
Further questions? Okay, thank you. Okay. Anybody else wish to speak to House Bill 2361? Okay, I'll close the hearing on House Bill 2361. And at this time, I'd like to revisit the 2024, the Safe Haven Baby Bassinet Bill. As you know, that we passed that out. It was on the House floor, and it was returned back to our committee for a little bit more work. Jesse, you want to give a real brief summary of the bill?
Sure. Thank you, Madam Chair. Good afternoon, committee. House Bill 2024 amends current law that allows a person to surrender an infant that is less than 60 days old, is not a victim of abuse or neglect, to an employee who's a facility, who works in a medical facility, a fire station, a police department. And so what the bill does is it allows those same facilities to install special newborn safety devices, which require alarms, checking, et cetera, as outlined in the bill. And then the current law gives the person who surrenders that child immunity, civil and criminal immunity from civil or criminal liability for the surrender of the child. And so that would also extend to the surrender of the child by placing in such newborn safety device.
Okay, so we're going to work this bill again, and I would ask if there are any amendments and call on Representative Carr.
Thank you, Madam Chair. I would like to introduce an amendment, and if Jesse would be so kind.
Okay, Representative Carr, would you like to explain the amendment, or we can have Jesse, whichever way you wish.
If Jesse would be so kind, that would be fine with me.
Thank you, Madam Chair. Thank you, Representative. So the amendment before you has its first change on page 1, and I'll explain that later. But so on page 4 in line 11, it requires an employee of a facility, when an infant is delivered, it shall not reveal the name or other personally identifiable information of a person who delivered the infant unless there is a reasonable suspicion that the infant has been abused or neglected. This amendment proposes to strike has been abused or neglected and insert suffered great bodily harm, so that that employee of the facility shall not reveal that person's identity unless there's reasonable suspicion that the infant has suffered great bodily harm. And then on that same page, down in line 42, it's striking the language for action taken pursuant to this section only, and that relates the action taken pursuant to this section is the surrender of the infant. On page 5, starting in line 9, this section relates to the qualifications to receive the immunity. And so in subparagraph C, in line 9, one of the conditions similar to the above change is the infant was not abused or neglected by the relinquishing parent prior to such delivery. All after the infant has been struck and inserted is not suffered great bodily harm. So a person who surrenders an infant to a newborn safety device and that infant has not suffered great bodily harm, that person shall be immune. And then what also exists in the statutes, in the criminal statutes on the last page, you have 215605. Subsection D references this safe haven, newborn safety device statute stating, yes, you do have immunity if you follow all the qualifications in that section. What you have here is an amendment to amend bodily harm to great bodily harm, so that we match those two statutes so that there is not a conflict for the courts to decide when evaluating whether someone has immunity. And so this makes those two statutes consistent, that immunity consistent with the surrender, and then the other changes to the bill are just the title and repeal or inclusion of that statute, that criminal statute.
Okay, so Representative Carr has introduced this. Do you want to put that in the form of a motion?
I move that we introduce this amendment into House Bill 2024.
Okay, it's been moved by Representative Carr and seconded by Representative Johnson to amend. Discussion on the amendment. Representative Carr, do you want to make any other explanatory? Oh, Representative Johnson.
I would really like to thank the opportunity to work with my colleagues on this to make this even a little bit better as we work with kids, and I appreciate the assistance from my fellow colleagues.
Any other discussion on the amendment? Representative Wagoner.
Yes. I guess I'd like to understand why we would be dropping the abuse or neglected to go to the word suffered great bodily harm. Well, why does that make sense? Somebody who's...
Representative Carr.
Thank you, Madam Chair. So the intent there is so that by changing it to great bodily harm and dropping the neglect could be just a matter of opinion. Neglect could be something as simple as a diaper rash. You know, have you been neglecting the child in that fashion? So that would be essentially the reason why the neglect was dropped.
Representative Johnson.
Thank you, Madam Chair. As a special investigator of child abuse cases, there are many that are very simple, but yet technical would be defined as an abuse. And clearly we want to protect that child, and that by parents that are afraid of surrendering the child for prosecution, we might miss a kid. And I think it's more important to, as an investigator, we had very strict standards on what became serious. And clearly this term, which we researched, is a good definition. It's almost immediate that you will know there is an issue. And so we were very comfortable with this. Thank you, Madam Chair.
Representative Wagoner.
Okay, I mean, I would agree that has a good plausibility reason, because you're dealing with somebody who has to be 60 days or younger. But then my secondary question would be, then why would we go ahead and change the totality of the statute, which covers children under the age of 16 just in general, and turning aggravated abandonment of a child into just has not suffered bodily harm, into making it has not suffered great bodily harm? I mean, I understand you're trying to make a consistency thing, but it seems like you're taking something that's a specific application to kids 60 days and younger and applying it generally to the entire statute on abandonment of a child of any age. I mean, does that make any sense? I mean, some of you are lawyers, maybe you guys could weigh in on that, because it does strike me as odd. I mean, I understand the consistency, but it seems like maybe that's not a good statute change, you know.
That's a really good question, and we've spent a lot of time on this since we were on the floor. So I'll turn to Jesse for the expert opinion on this.
Sure. Yeah, thank you, Madam Chair. Representative Wagner, in 215605, all you're doing in that subsection D, it states that you have to comply with the provisions of 382282. And since one of the provisions is the child is less than 60 days, that has to also be met. So the conditions that are required in the statute of the 60 days apply to get this immunity, and it's not changing the A through C aspect of 215605.
So I'll follow up. So what we had originally done, and the reason why this created so much confusion on the House floor, was what we thought we were granting immunity from any kind of prosecution, but they were really only getting immunity for the abandonment, for actually turning the child over. So then we had to go into some of the criminal statute in order to add in, and then that language was put there specifically to be consistent. Does that make sense? Did I say that right? Okay. Representative Lewis.
Thank you, Madam Chair. First, a question, and then I guess a comment. Jesse, do you or anyone else here know if great bodily harm would include sexual abuse?
Madam Chair. Representative Lewis, so there is no definition of great bodily harm throughout the statutes that I could find. So whether a court usually includes that, then yes. If a court usually does not include that, then no. But I don't know necessarily the term of art that the court uses if it includes it.
Representative Johnson.
Thank you, Madam Chair. One of the issues in investigating is sexual abuse of a child that's under 60 days. There are some very distinctive events that must take place. In many cases, that's anal intercourse, penetration of the child's vagina, that cause damage and tearing and are very noticeable. And so those under the definitions when I investigated would clearly have met the standard of great bodily harm. Thank you, Madam Chair.
Thank you very much.
Okay, further questions? Representative Carr, if you have, you can ask a question if you like, or you can close on your amendment.
Thank you, Madam Chair. I'd just like to add a final comment. I'd like to echo the sentiments of Representative Johnson. As many of you are clear to know, this is my freshman session, and I would like to thank Madam Chair, Representative Johnson, as well as Representative Owsley for their assistance in working through this. I'm not sure what normally takes place. However, if this was any indication of the way we work through our differences, I would say that that this will continue to be a very pleasant session. I'm thankful for what I've learned during this, and I'm also thankful for the way that I was, for lack of a better term, handled. And with that in mind, I move that we close.
Okay, you've heard the motion to amend. All in favor say aye. Aye. Opposed, no. All right, thank you. And thank you for all your work on it. I think we've made it a better bill than what it was before, so I appreciate it. So we need to pass this bill out again. So Representative Neighbor. Oh, I'm sorry. We have a further, another amendment. Sorry, Representative Owsley.
Thank you, Madam Chair. And I do have an amendment. I'd ask Jesse to pass that out and give us just a brief overview. And this amendment deals more with the underlying statute than it does with House Bill 2024. I will just say that I had some questions as well as some other folks that I talked to, And I think we can just add a little bit of clarifying language and update the statute a little bit, but I'll let Jesse go into detail.
Is that okay?
Jesse? Yeah.
Thank you, Madam Chair. Thank you, Representative Owsley. So the amendment in front of you committee today, the first change is on page 2 in the definition section of section 2. So it includes a definition of infant, which means a child that a licensed physician reasonably believes to be not more than 60 days old when surrendered to a facility that is described in the statute or to such device as the bill proposes, and is not an abused child or a neglected child, such as those terms are defined in KSA 215602. And then that requires some redesignation of the definitions, which is what you find on page 3. And then in line 28, what you have is not a substantive change. It is just a consistency aspect of not more than 60 days old. So that matches what is stated in the definition and throughout the statute. On page 4, line 34, you have that the law enforcement agency, if they receive such child or child has been surrendered, the law enforcement shall report that surrender of the infant to the secretary, in addition to delivering an infant to a facility that's described in the section. And then lastly, on the very last page, page 6 is where you're going to see more of a substantial amendment to the statute with subsection L, which states that a facility described in the section that receives an infant that is surrendered under the section shall make available information to that relinquishing parent. But that parent is not required to accept that information. The information to be made available will include a notice stating that 60 days after the surrender, the secretary shall commence proceedings for the termination of parental rights of that child and the placement of that child for adoption. A list of providers that provide counseling services on grief, pregnancy, adoption, or other placement or care of the infant that has been surrendered. Language of this section, so this law, the rights of birth parents, including a questionnaire that a birth parent may answer questions about medical or other background information of the child, including any information required by subsection K. As a reminder, that subsection K is an amendment that inquires to whether the child is a member of an Indian tribe. So that is also included here. And then lastly, a brochure on postpartum health for that relinquishing parent. The way that this information shall be given or looks like will be prescribed by the secretary. And additionally, the secretary shall be required to maintain that medical or background information questionnaire under the subparagraph C on a public website. To access later. And then another new subsection M, it prohibits certain individuals from publicly disclosing any information concerning the relinquishment of the infant or any individuals involved with that relinquishment, except as otherwise required by law. And those are the individuals that are the medical professionals, employees, or other persons engaged in the administration or the operation of the facilities in the section, the device, agencies providing services for children in need of care, or any related to the location where the infant has been surrendered under the section.
Okay, Representative Owsley, would you like to make a motion to
Move to amend House Bill 2024.
Is there a second? Okay, there's a second by Representative Hoagland. Do you say it Hoagland or Havland? Hoagland, yeah. Representative Hoagland is second. Discussion. Representative Owsley, you want to?
I think Jesse did a good job describing it. And again, just some of the concerns that, I heard on the floor and in the halls about, I don't think a lot of people knew that this statute existed until it was brought to the floor the other day. And, the 60 days old was definitely a question. And then the information we can provide, the more information, the merrier. And so we put this together.
Representative Wagoner.
I think this makes sense. I do have a couple questions, either, I don't know, for Jesse or for any of the legal minds here. But, on page 2 in the balloon part, you are using the words "is not an abused child or a neglected child" rather than what we've just switched to about great bodily harm. And then further on page 3, line 29, it just says "has not suffered bodily harm," where maybe it should say "has not suffered great bodily harm." I mean, if we're trying to have a certain consistency. And so I don't know if those things are significant, but they did leap out to me.
Good recognition. Would you be okay with making that consistent throughout?
Being as, thank you for pointing that out. Thank you, Madam Chair. And being as this amendment has come after the previous amendment, I'd be fine to bring it in line with what the committee just worked on.
Okay. Jesse, do you have some comment? Okay, good, please.
Thank you, Madam Chair. So Representative Owsley, that kind of looks like in that definition of infant is not an infant that has suffered great bodily harm. It would be the most consistent with the previous amendment.
I will trust your opinion upon it.
Okay. Representative Lewis.
Thank you, Madam Chair. So kind of following on that thought, it's not clear to me why we need to define infant at all to accomplish the goal here, but I may be misunderstanding where we're trying to go with the amendment.
Representative Owsley.
Thank you, Madam Chair. And I think as the bill refers to the 60-day-old, the important part of that definition is the physician opinion upon if the infant is 60 days or less.
Okay. So so wouldn't we then strike everything else in that definition? I don't know.
Representative Owsley.
Right, that makes sense to me. But this all kind of gets conflicting.
Representative Owsley.
If it's okay with my second, I'd be fine with adjusting that definition.
So as I understand it, it would read something like infant means a child that a licensed physician reasonably believes to be not more than 60 days old when surrendered to the facility described in subsection C1A, or a new born safety device, period. That's my understanding.
Jesse.
Madam Chair, Representatives, that is something that could be done. But there could also be the definition of infant. If an infant means a child that a licensed physician reasonably believes to be not more than 60 days old and has not suffered great bodily harm in addressing the concerns in regards to duplicity.
I don't understand. I just don't understand why we're defining an infant that way when we're then in the rest of the bill we're explaining under what conditions the person who relinquishes it isn't subject to prosecution with the no bodily harm and all the other stuff. Just, maybe I'm not understanding it, but.
Just a minute. Representative Johnson, and then Howard.
Thank you, Madam Chair. For purposes of the word infant, the CDC defines as from 0 to 1 year. And now, physiological development and training in schools also defines that from 0 to 1 year. So I see a contrast here that conflicts just by definition with established academic definitions of the term. Thank you.
Just, Madam Chair.
Representative Owsley.
Thank you, Madam Chair. Now, I would just bring to the body's attention that line 37 of page 2 says, as used in this section. So that definition would be per this conversation.
Representative Howerton.
Thank you, Madam Chair. I think with the definition, what it seems to imply to me, I'm not a lawyer, is that the physician is not only determining the age of the child, but the condition? Is that what we're meaning to imply here? Like, does the physician have to do the exam or see? That's what my concern is on that definition.
Representative Owsley.
You know, I hadn't considered that, but somebody's going to have to conduct the exam, and I would prefer it to be a physician, you know.
Representative Pickert.
Thank you, Madam Chair. It doesn't have to be a physician. It could be a nurse practitioner, you know, so it depends on the community. If it's a little tiny community that doesn't have a physician on board and that baby needs to be examined right away, but yeah. But that would make, just that the baby is going to be examined helps rule out great bodily harm. You know, the baby could have a head injury if, you know, they look okay, but that exam is really important. Thank you.
Representative Humphreys.
Thank you. I tend to agree with Representative Lewis that we're defining infant, and I think it's great to say a licensed physician reasonably believes to not be more than 60 days old when surrendered and so on, but then stop at a newborn safety device, because it seems redundant to talk about the great bodily harm when clearly, as it's like in the next section, we mentioned that already. I mean, that's part of the bill, is that the person, that the baby hasn't suffered great bodily harm. I mean, we already have that in there. So it seems like defining an infant that way, I think the age, that makes perfect sense to make that really clear. But to go on, I don't understand the reasoning for that when the bill goes on to describe that quite well, that they cannot have great bodily harm.
Representative Owsley.
Thank you, Madam Chair. And Jesse, could you read what you interpreted the definition as again? I know that we'd struck after described in subsection C. You read it once, and I want to make sure that we're all working off of that.
Sure, Representative Owsley. I've repeated 2 different definitions, so let me know which one. The most recent one I stated was infant means a child that a licensed physician reasonably believes to be not more than 60 days old and has not suffered great bodily harm. One previously stated, and the only change made to that was the great bodily harm part would be infant means a child that a licensed physician reasonably believes to be not more than 60 days old when surrendered to a facility, described, or a device, and has not suffered great bodily harm.
I think the shorter definition captures the intent of the amendment and hopefully eliminates some of the duplicity. However, I will state sometimes suspenders and a belt is not a bad approach neither.
Is that okay with the second, too?
Could I offer that we change licensed physician to licensed medical provider?
Yeah, I thank you for that, too. I was going to address that after we got the sentence structured done. Okay. Okay, so you're okay with the, with changing the motion, and are you okay with changing that to licensed medical professional? Yeah, I'm asking you.
Having not served upon a health committee and not knowing the terminology, I'll lean to the experts on the committee. I am perfectly fine with it. I don't want to potentially put a community, at risk for not being able to have the proper provider perform. So I'm getting a head nod, so yes, I'm fine with it.
Yeah, I was just going to ask the revisers to make sure that that was consistent language with what's used in law, or if we need to, yeah, that's good. So, okay, while they're looking at that, Representative Underhill, did you have your hand up a minute ago? I was going to say the same thing. Okay, gotcha. Gotcha. Okay. Representative Humphreys?
So just to clarify, once we figure out what we're going to say instead of physician, did we include, I know you said the shorter definition, Representative Owsley, but I wasn't sure. So before we do it, if we can just read the whole thing so we know what we're voting on. Thank you.
Gotcha. Representative Howell?
Thank you, Chair. Not to further muddy the waters here, but it appears to me, just kind of scanning over this bill, sometimes we're using the word infant and sometimes we're using the word newborn. So, and if I understand what Representative Lewis was kind of questioning, was actually about the word infant. Now, maybe I misunderstood, but so maybe that's part of the confusion that's going on here. And so I'm not suggesting a solution. I'm just saying it might be part of the confusion, I guess.
Okay. Let's go back to the medical provider.
Okay, thank you, Madam Chair. So I'm referencing a bill this committee has already seen and passed out. So when you're talking about 2034, you're talking about a care provider. The definition that bill uses is a person licensed to practice medicine and surgery, an advanced practice registered nurse, or licensed physician assistant. So that is a definition or a description this committee can adopt, or healthcare provider could be a shorter term, but may include more health professions than those listed in the definition I stated from the care bill.
Yeah, that's the concern, is opening it up to. Representative Howerton.
Sorry, thank you. Madam Chair, so if it's a care provider, if that is one of the options, would you have to be in that network?
Madam Chair, Representative Howerton, I'm not suggesting you use care provider, but the description of a care provider is a person licensed to practice medicine and surgery. So yeah, there's that general aspect of defining a care provider, but not using care provider, the term, to put into this bill.
Representative Lewis.
So I think to just prevent confusion as to what we're trying to do, that we should delete the definition of an infant completely and just include the concept of having some licensed healthcare provider determine, now I'm looking at the provisions which are criteria for obtaining immunity. When we say one of them is the infant was not more than 60 days old when delivered by the relinquishing parent. The problem is we define infant as somebody that's not 60 days old, and then we have that as another criteria for the immunity. It's like stating it twice, and so I don't have a problem. In fact, I think it's a good idea to have the determination of age made by somebody who knows what they're talking about. And also, quite frankly, although I'll leave this to maybe Representative Johnson has some ideas on this, to have that same healthcare provider determine whether that person has experienced great bodily harm. But we could just fold that into the criteria that we set forth for the immunity. I think it would get to what Representative Housley's trying to get to, and just avoid duplicative statements about. That's why I'm objecting to the amendment as stated.
Okay. So, hang on just a minute. So we're dealing with Representative Owsley's amendment, the balloon amendment. And so I'm going to go back to him for what his preference is, and then we can vote on it one way or the other then. But thank you. Representative Owsley, and then I'll come back over here.
Thank you, Madam Chair. And I understand your concern, and I think as long as we get it in there, I'm not going to be sticky upon where it's at. Because I think, like you're saying, to put it in where it mentions is 60 days old, to have that, the licensed provider believes not to be more than 6 days old, covers my concerns, covers some of the concerns that I've heard outside of this committee. I'm not seeing where we would put it in the bill.
Representative, you want to go ahead and use your mic? Yeah.
Sorry about that. Yeah, that might possibly fit more on page 3, somewhere lines 29 or 30, to include an infant who is not more than 60 days old and has not suffered great bodily harm as determined by a licensed medical physician or medical provider.
You okay with that?
Jesse, you think we can make that work?
Yeah. Jesse?
It's fine with me, as long as it fits in the bill.
That's fine.
You want to say that?
Madam Chair, that would be a fine place to include that, as well as it would most likely need to be in subsection H 1 cap B, which is page 5, line 8, when that does the qualifications that child must be 60 days. So that's where you would insert.
Oh, Representative Lewis.
Yes, that's where I was suggesting it go. And also in C, the infant was not, now we're saying, doesn't show signs of great bodily harm, that the physician or healthcare provider, whatever, would make that determination as well. That's the intent, I believe, of Representative Owsley's bill or amendment.
Thank you, Madam Chair. So Representative Lewis, all those changes in Amendment 1 regarding great bodily harm will be made. This second amendment, because that doesn't directly conflict with that, won't take that part out.
I understand. I'm
okay.
not suggesting that it would. I'm just saying that as we've already amended it, that's what it currently provides, and we'd have the physician do the analysis. Yeah.
Representative Neighbor? No? Anybody else? Representative Pickert?
Thank you, Madam Chair. So just depending on how this is worded, it sounds, I think it just needs to say something about the licensed medical professional, something about determined, that the child is 60 days or less and has not had harm. So it indicates that the provider is determining both of those things. Because sometimes when I've heard this, it sounds like, well, they determine the age, but the medical harm, no. So it just needs to indicate that the provider determines both. Does that make sense?
Yep, makes sense.
Okay, thank you.
Jesse?
For clarity from the amendment maker, does that mean that both, I'll leave that up to the chair. Does that mean in cap B, you reference that 60-day determination is made provider, and then also you keep cap C and that determination is made by a provider? Or are you proposing to put B and C together? Yep. Page 5, line 6.
Madam Chair.
Representative Owsley?
Thank you, Madam Chair, and thank you, Jesse. I think to reflect the comments just made that we want the provider to not only determine age, but lack of great bodily harm, I think to combine them makes sense.
Okay, Jesse?
So to confirm what that language could possibly look like in the committee report, you would have cap B, the infant was not more than 60 days old, nor has suffered great bodily harm as determined by a licensed medical provider, as the committee decides.
I want medical. To the definition, just use the full definition from the care licensed physician and yeah, go back to that.
Okay, so that the medical provider aspect of that qualification would read a person licensed to practice medicine and surgery, a registered nurse practitioner, and a physician's assistant. The registered nurse practitioner.
PRN, yeah.
Yeah.
Okay. Where are we at? Representative Owsley.
Thank you, Madam Chair. And thank you, committee, for your patience and your input. And welcome to the Kansas Legislature. And I will close upon my amendment. Upon our amendment. I will close upon our amendment.
Talk. Representative Humphreys.
I don't necessarily, I don't have anything to disagree with, but I think it's important that we notice that there's about an almost one-page other part of your amendment. I don't want people to forget that we're not just talking about the definition of an infant. are they, you know, I want to make sure people are okay with this section too. Thank you.
All right. It's been moved to amend. Representative Lewis?
I have a question. So when we go to our vote now, are we voting on the amendment? No, what are we voting
Whole
on?
thing.
Anything?
This is a balloon amendment, so it's the whole thing. The whole amendment. We're not back on the bill yet.
Right. And so is the amendment what I see on my page, or as discussed, the changes that we've discussed?
And that's a good point. Let's go back through it. Thank you. Jesse?
Okay, thank you, Madam Chair. So from my notes, the amendment would, in front of you, not include any changes on page 2. It would include the change on page 4 to report the surrender. So no, on page 3, since there's no infant definition, there's no reason to redesignate that change of not more than 60 days old as examined by a person licensed, et cetera, as discussed there. Page 4 has that. That will be included. And then page 4, that report by the law enforcement to the secretary. And then page 5, the qualifications to receive immunity. The amendment would strike C, and in cap B, it would be the infant was not more than 60 days old and has not suffered great bodily harm as determined by a person licensed to practice medicine and surgery, as we discussed, period. And that would be the end of the qualifications, and you would move on to that paragraph 2. And then on page 6, you have the large block of subsection L and subsection M.
Okay. Any questions on what we're voting on? All in favor to amend, please say aye. Aye. Opposed, no? Okay. Motion to amend. Are there any other amendments? Representative Neighbor. Representative Howerton.
Thank you, Madam Chair. So Representative Howe mentioned newborn and infant. Is that a problem with the terminology? Or is that anything that needs to be cleaned up? That's my only question for clarification.
Jesse?
So what you're seeing is the baby bassinet, the baby box, the safe haven device, and was amended last time by this committee to be called a newborn safety device. And so the word newborn should only be used in this section in reference to that device. And all other times it should be an infant.
Representative Neighbor.
Thank you, Madam Chair. After much in-depth discussion and several amendments that have been worked and reworked, I would move that we pass out House Bill 2024 favorably as amended.
Okay, it's been moved by Representative Neighbor, second by Representative Johnson to pass out favorably. Is there discussion?
I close.
Okay, thank you. Thank you. Okay, all in favor of passing out favorably as amended, please say aye. Aye. Opposed, no. Okay, I am so sorry we did not get to work 2299 today. We're meeting Monday. We're meeting Monday. No, it's not too late. Committees still meet Monday and Tuesday. Yeah. Or we can come back on Friday. I have appropriations Friday. We can meet Friday afternoon. No, we'll work on it Monday. We've got a hearing on Monday as well on House Bill 2407. And be prepared, we might work one of the other bills that we've heard that we haven't worked yet, so we're adjourned. Oh, no, one more thing, sorry. I retract. Representative Johnson.
Approve the minutes as,
Use your microphone.
move we approve the minutes as presented.
Second.
Okay, moved and seconded to approve the minutes of January 30th. All in favor, say aye. No discussion allowed. No, I'm just kidding. Does anybody have any questions or additions or corrections? Okay. Motion passes and we are adjourned. All right.